In this video, I want to take a look at some changes that were introduced around employment law in December 2022. The European Union Transparent and Predictable Working Conditions Regulations of 2022, Statutory Instrument 686 of 2022, is the relevant statutory instrument which gives effect to the European Directive. The changes that brought about include changes to the Terms of Employment Information Act 1994, the Organisation of Working Time Act 1997, the Protection of Employees Fixed Term Work Act of 2003 and the Workplace Relations Act of 2015. First change is the Terms of Employment Information Act 1994 includes a change to the 5-day statement that was previously required and provides certain further information must be provided in the 5-day statement to be given to the employee. In addition to that, the statement of terms of employment, which was obligatory pursuant to the Terms of Employment Information Act of 1994, must now be given within 1 month of starting the job, not 2 months. So this was 2 months, now it's 1 month. The probation period. The maximum probationary period now permissible from the 1st of August 2022 is 6 months, unless in certain limited exceptional cases when it can be extended to 12 months. But the ordinary course of events up to now, the usual practice would be it was for 6 months and extendable to 11. It is no longer permissible to extend the probation period to 11 months or 12 months, except in limited exceptional cases. You need to have a look, and we'll have a look there in a minute, at the limited exceptional cases. The Organisation of Working Time Act 1997, there are some changes to ensure greater predictability of work. In relation to fixed-term workers, where an employee is working on a fixed-term contract which provides for a probationary period, that probationary period must be proportionate to the fixed-term contract of employment. In other words, you couldn't be on probation for the entire length of the fixed-term contract. The Workplace Relations Act of 2015 is amended as well to allow complaints to be heard in respect of these regulations. As I say, there's another one there to do with parallel employment. An employee cannot be penalised for or prohibited from taking up employment with another employer outside the work schedule established with the first employer. So that gives greater flexibility for an employee to take up another job, perhaps a part-time job or whatever. The relevant statutory instrument is number 686 of 2022. And to take a look at that, I want to just double check on the probation situation. So the maximum duration of the probationary period will be 6 months. That's the maximum period. The probationary period of a public servant shall not exceed 12 months. So a public servant is different from a private sector worker. The probationary period referred to on an exceptional basis may be longer, where such longer period does not exceed 12 months and would be in the interest of the employee. So where it might be in the interest of the employee would be where an employer is in two minds after perhaps 5 months, and if the decision is between terminating the employee, terminating the contract of employment on the basis that the employee is not suitable, or extending it to 12 months for the employer to have more time to look at the situation and see how the employee does and give the employee the opportunity to meet the required standard, then in that exceptional basis it can be extended to 12 months. The relevant instrument, statutory instrument, as I say, is number 686 of 2022, and you can Google that. You'll find it on irishstatutebook.ie. I hope you find this video useful. If you do, I would appreciate if you gave it the thumbs up down below. Thanks a lot.